Good question. So a lot of times you'll hear lawyers talk about or advertise no fee, no recovery, or no recovery, no fee. What they're talking about is a contingency fee case. What that literally means is that your duty to pay the lawyer something is completely contingent upon the lawyer recovering for you on your claim. So for example, in a car wreck case, there might be a contract with the lawyer that's a contingent fee contract. And the lawyer might say, I'll take a third of any settlement that we're able to obtain for you on your personal injury claim for this car wreck. And I'll take 40% if it goes to trial and 50% on appeal. That might be a contingency fee contract that you see. You only owe the lawyer those percentages if your case ends up in one of those categories. So if it settles, you're going to owe the lawyer a third of the settlement. If it goes to judgment to a jury, you're going to owe your lawyer 40%. If your lawyer has to hold that case up on an appeal, meaning he's probably or she's been fighting for you for 5 or 6 or 8 years, lawyer's going to take, yes, half of your recovery. That would be a very customary contingent fee case. The other thing to remember is, in the state of Missouri, every contingency fee case must be memorialized in writing with the client, meaning the lawyer should have you sign a contract in writing, and that's why they ask you to do it. What a lot of people don't understand is we have insurance for a reason. Every person licensed to drive in the state of Missouri is by law required to have liability insurance coverage that covers the negligence of that driver in the event they're in a car wreck. So even though you might be making a claim against a family member, maybe your uncle was driving the car and was negligent and you got hurt because of your uncle's negligence, yes, in theory, you'd be making a claim against your uncle, but your uncle's going to have insurance that can actually pay that claim. The lawsuit is only going to become necessary if the insurance company is unreasonable in trying to settle the case and put a reasonable value on the claim. So in theory, could you have to go to court against your uncle? Yes, in theory, that might happen. For people who are just generally afraid of litigation, you certainly could hire an attorney with the agreement that you're going to try to maximize the settlement value and not go to court. However, that would take away some of your attorney's leverage because at the end of the day, the lawsuit is the one thing that gets people's attention and can actually work to discover more information about the case, to build your case even better, and potentially get an even greater recovery when lawsuits are necessary.